Welcome back, students. I'm Professor Lawrence Likar, Department of Justice, Law, and Security at LaRoche College, and this is our fourth video for the online course in constitutional law. During this video, we're going to concentrate on the areas of detention, arrest, and the use of force relevant to Chapter 3 in your textbook. Let's start by looking at the Fourth Amendment, because the Fourth Amendment is what controls the questions of detention, arrest, and the use of force. Also search. We'll be covering search in more detail on the next video. But today, we're really looking at the arrest, the detention, and the force issue itself. But the Fourth Amendment and the provisions that I'm going to read on the Fourth Amendment, realize that they apply equally to seizures and searches. So although our emphasis is on seizures, the law that we'll be discussing, how the Supreme Court has interpreted the Fourth Amendment, is the same law that it applies when it looks at the search aspect of it. Now, the amendment itself, the right of the people to be secure in their persons, houses, papers, and effects. Now, those phrases, persons, houses, papers, and effects, these, like everything in the Fourth Amendment, has been subject to interpretation. Now, effects, EFF, ECTS, that's been interpreted to mean just about anything. For example, one that's very common, vehicles. Obviously, they weren't driving vehicles when the Constitution was drafted, but when we talk about the living Constitution, this is an example of how one term can be given different meanings, as the years advance and things change in our society. The next clause after that is that against unreasonable searches and seizures shall not be violated. The concept of unreasonableness is extremely important, and we'll be talking about that throughout this video. No warrants shall issue. We're talking about the Warrant Clause now. No warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. When you look at the Fourth Amendment, you realize that the first major clause of the First Amendment deals with the concept of reasonableness, because it basically states that our right is to be protected against unreasonable searches and seizures. The second provision specifically deals with the warrant provision, the idea that no warrant. Now, there's the idea of no warrant shall issue. If you look at that, one interpretation of that is that the warrant is such a powerful instrument that you should never issue a warrant unless two factors: probable cause exists, and that the warrant itself particularly describes the place to be searched and the persons or things to be seized. And again, all these provisions apply equally to seizure of a person, seizure of property, or search of a property, or search of a person. All right, let's go back to the reasonableness requirement, because every type of arrest, seizure, or search that we talk about has to meet one requirement, and that is it reasonable? Now, that standard is an objective standard. It's how a reasonable person viewing this would deduce that the behavior or the search or the arrest was reasonable. So it's not based on a subjective standard of anybody who's engaged in a search or a seizure, but an objective standard using a reasonable man, in many cases in this particular amendment, using how a reasonable police officer in that position would have acted. The warrant clause itself is, the warrant clause today has been interpreted to mean that it basically is, well, it's treated almost as a preference. Now, there's debate over this issue as to whether there's a preference. It's just that we do know that through judicial interpretations that the warrant, having the warrant already in effect in instituting a search or a seizure, it does two things that are important. One, it protects you, if you're an agent of the government, from being sued civilly. It also protects, in most cases, the evidence that is seized from being suppressed and and actually possibly excluded from being used in evidence. So those two, when we look at those two factors, the primary one is reasonableness, and that will run through everything we're talking about. Seizure. You'll notice the Fourth Amendment never mentions arrest. It only mentions search and seizure. In regard to the seizure issue, we have two basic types. One is the full-fledged seizure, and that what the amendment was, and when it was initially drafted, it was referring to what today we would refer to as an arrest, a full custodial situation where the individual or the property, but let's talk about the individual, is basically realizes that his ability to leave is totally up to the agent of the government that has seized him. The other type of seizure is a recent development, relatively recent. It's the concept of a temporary investigative seizure or a temporary seizure for the purpose of investigative activities. That particular type of seizure was not something that the framers actually they actually didn't realize that this would become such a common type of event in society today. We had kind of a primitive form of law enforcement when the Constitution was drafted. We didn't have organized police forces, crime. There wasn't standardized procedures for carrying out investigations. Police didn't routinely patrol. They may have had night watchmen. They had constables. They developed what was an early concept of the marshal. But the idea of what we see today, where we have police on patrol, vehicles on foot, the idea that there would be these constant exchanges between the citizens and law enforcement, that just was not, the framers just were not dealing with that. So it's taken the Supreme Court to interpret the Fourth Amendment in regard to current practices in law enforcement. And one of the things that they were faced with was the issue of temporary types of seizures in which probable cause was not evident. And that was a problem. Under the First Amendment, search and seizures required probable cause. Well, what about the police officer that asked somebody on the street, well, look, typical, stop, sir, I'd like to ask you a few questions. That is not an arrest. It's not what the Fourth Amendment initially thought of as a seizure. Well, in that particular situation, which happens frequently, and in fact, you are being seized on a very temporary basis without any type of probable cause. How do you handle that? Well, the Supreme Court was faced with this, and you'll see this in one of your cases in your textbook for Chapter 3. Remember, the second half of the textbook has the chapters that are relevant to your particular chapter. And Chapter 3, the Terry case, Terry versus Ohio, was where the Supreme Court actually was faced with this issue of the agents of the government, the police, temporarily seizing somebody based on less than probable cause, and then going further, actually searching the individual, again, without any type of probable cause, but just basically suspicion that the individual might have been armed. So and this escalated into an arrest in the Terry situation, but the court had to determine what should they do with this type of seizure. One that was for the purpose of investigation initially, not for an arrest, and what would be the legal standard, or would they prohibit it completely? Well, prohibiting it, that type of seizure completely would have been it would have just devastated the way we conduct law enforcement in the United States. This type of investigative detentions for a limited period of time with very little belief except for a generalized suspicion that there could be criminal activity afoot is something that is just kind of a routine practice and has been for actually probably for centuries. What the court decided in the Terry case was that for a temporary investigative detention, they would create a new standard, and that was a standard called reasonable suspicion. Reasonable suspicion of criminal activity. Now, it wasn't that if a crime had actually been committed and there was probable cause, there would be an arrest. This is a situation where the crime hasn't actually, the police are not aware of the crime having been committed, but they are aware that someone could have committed a crime or may be in the process of committing a crime. And they're asking these questions of a citizen to try to determine what their further action should be. And this always stops with a temporary detention. And to do that, the idea of the standard, the reasonable suspicion, those are facts and circumstances. And this includes information from other police officers. It could include records. It includes the officer himself, what the steps he took, what he observed. It also includes information from informants and citizens. So there are a variety of information that the officer will have on hand with him when he's determining whether or not to make the stop. He will also have all the inferences that a trained officer in his position would have gained from the information he has. And based on that, if he believes that there is a possibility, that a reasonable possibility that the individual he is approaching may be involved in criminal activity, that's a strong suspicion. At that point, he can make that seizure, but the Supreme Court in the Terry case and in later decisions put some limitations down. The main limitation is it is in fact a temporary seizure. Well, in one case, the Supreme Court said they would not go more than 90 minutes for the duration of the seizure. But again, that was based on the facts of the case, and I would think that the duration is still somewhat open to the factual circumstances. But generally, we're talking about a relatively short period of time. So we have the stop being made, and now we have the agent of the government actually going further now and asking questions, or in some cases, if he believes that he or she believes that the individual that is being stopped may present a threat, and in fact could be armed with a weapon. The Supreme Court has also allowed a certain type of search. It is a protective frisk, sometimes called a Terry search, or the pat down. It's a search that is just over the surface of the body. It is a pat down, and its only purpose is for determining whether or not the individual is carrying a weapon, because it is a protection search. It is not a search for evidence. So once that's done, now again, if there's something apparent that turns out to be, basically evidence of a crime or contraband, it's readily apparent to the officer conducting the pat down, then this is called a plain field search. Then basically at that point, that could be seized. But the reason for the search is the pat down, and it's for a weapon. Questioning, unlike a full custody situation, in these situations where you have a temporary detention, there is no requirement for Mirandizing the individual to advise the person that they have the right to be silent, that they have the right to have an attorney. And those issues do not have to be addressed in this situation, in the temporary detention situation, which is one of the reasons why, in some cases, this is a preferable type of stop for the police if they have any doubts at all as to whether there is sufficient circumstances for an arrest. Because once the arrest is made, well, that's a little different as far as what they can be asked. But temporary detention, basically just general questioning. Because remember that all these situations often start with just a voluntary encounter on the street. where the police may ask you, could you talk to me for a few minutes? Well, you may say yes, or you could say no. If you say no and you walk away, that is within the bounds of the voluntary encounter. If the police at that point decide, no, I don't want you walking away, I want you to stop here and talk to me for a little bit, now we've moved into the temporary detention. Because it's no longer voluntary, the police are now imposing a certain degree of control over your movements. But the issue now becomes whether or not that temporary detention is actually a full-blown arrest. And the court, if this is challenged later, because here's what happens. Basically, in these temporary detention situations, we sometimes get a confession. We sometimes are going to see the discovery of evidence, and it's going to be challenged later on the basis that you did not have probable cause in making the initial detention, because reasonable suspicion would not be sufficient. That's all you had was basically reasonable suspicion that in fact what you had was a full arrest. And again, it's this subjective test as to whether or not an individual in the person who is saying that they were arrested, whether or not someone in that position, a reasonable person, would believe that they were in fact not free to leave for an indefinite period of time, and that their liberty interest was now under your control totally. If that can be done, and you in fact did not have probable cause when you made the initial stop, then anything you gained afterwards, you could lose. You could lose in a suppression hearing. All right. Generally, when we look at the concept of unreasonableness in the cases that you're going to be looking at, and any questions that I may set out for you, in an exam, you have to look, what is unreasonable? Well, the first thing you look at is were there reasonable grounds for the seizure? And look at what the seizure entailed. Was it temporary or was it an arrest, a full custodial situation? The grounds are different. One is the reasonable suspicion standard, the other one is probable cause. So you're going to have to, that's the first question you look at, because if the grounds were not actually there, then that becomes an unreasonable seizure. The second issue that you would look for is whether or not there was a warrant, and whether or not a warrant was necessary in this situation. And in many cases, in fact most cases, warrants are not necessary. Although they give you these protections, they're not always necessary to make a seizure. In some cases they are. And lastly, in a seizure situation involving an individual, and actually it could even be in a search situation in some cases. Well, let me go back to the individual. Involving an individual. If you're doing a seizure, one of the things that could be an issue in reasonableness would be the amount of force that was used to make the seizure. If the force was excessive, again, it's unreasonable, which means it's an unconstitutional seizure. So, if the standard for the seizure was not met, reasonable suspicion for a temporary detention, probable cause for an arrest, it's unconstitutional. If a warrant was required by Supreme Court interpretation of the Fourth Amendment to the particular facts of the case that you were involved in, if a warrant was required and there was no warrant and none of the exigent circumstances that could allow you to dispense with a warrant were present, then that is an unreasonable seizure. And lastly, excessive force. If excessive force is used, because basically that will basically, even though everything else is right, if the force was unreasonable, then that becomes an unconstitutional seizure. What I'd like to do a little bit today, I'm looking at some of the cases in Part 2 of your textbook, and some of this, we're going to look at a couple of these cases, and when you go through there, you'll notice in Part 2 for Chapter 3, you have United States versus Drayton. United States versus Drayton. This is an unusual case in that it was a bus seizure, and we had the police coming on the bus. They were basically looking for drugs and weapons, but everything they did in that case was a voluntary encounter. They never went beyond the bounds of the voluntary encounter until they developed enough probable cause to make an arrest. It's an interesting case because you can see how far the police can go and keep the encounter within the bounds of a voluntary encounter, which means the Constitution is not applicable. The voluntary encounter escapes the constitutional review once it's considered it hasn't went beyond that. So it's a good case to analyze. Then I'd like you to look at the Hodari case. The Hodari case basically defines when you are seized, and when you're seized, basically under the Hodari case, the Supreme Court's interpretation is they were emphatic about this. So when you're restrained from exercising your right to liberty by either submission to legal authority, stop, you're under arrest, depending upon what we have here, under arrest, probable cause, stop, I'm going to talk to you for a little bit, or hold up there, don't move. That could be a detention where the reasonable suspicion, or you're actually physically restrained. Again, normally that will be an arrest. Occasionally it could be a detention. The standard is necessary to have been met before that happens. In the Hodari case, we had an issue of crack cocaine being thrown away by an individual who the police wanted to talk to and who ran. They threw the crack cocaine away, the police tackled him, they had a little struggle, he was arrested, and the issue became what happened to the crack cocaine, because there was not sufficient reasonable suspicion at the beginning to have made the temporary seizure. But in fact, the seizure didn't actually take place, according to the court, until he's actually physically restrained, because he never actually consented to the seizure. In fact, he never submitted to their legal authority until he was tackled. The cocaine had been thrown away before that, and the court said basically there was that did not come under the exclusion. It could not be suppressed or come under the exclusion rule because it was voluntarily abandoned by the individual. So Hodari is an interesting case. Pennsylvania law differs in that area. In the Terry case, looking at the detention issue again, what we look at for temporary seizures, the court has a totality of the circumstances. They look at all the factors are involved in determining whether or not that standard of reasonable suspicion would be met. The Wardlow case, Illinois versus Wardlow, is an important case dealing with the running concept, and this often gives police a little bit of a problem. If someone runs, does that give you enough probable cause standing by itself, or enough reasonable suspicion to act? It does not give you probable cause to make an arrest. But flight from you when you're trying to, a police officer is encountering somebody and trying to talk to them and they run, that is, under Supreme Court interpretation of the Fourth Amendment, flight itself would be enough to have a detention of that individual. That would give you enough reasonable suspicion to make a detention, to make a detention. Usually there's obviously other factors that went into that, but that seems to be standing alone. Flight, when you're trying to have a conversation or trying to have an encounter with somebody on a voluntary basis and they flee from you. In the Florida versus JL case, you're dealing with an informant, and the informant's anonymous. The Supreme Court interpretation of how you handle an anonymous informant as to whether or not that type of information can be used for reasonable suspicion or for probable cause. Essentially, anonymous informant information standing by itself will not be sufficient. Standing by itself will not be sufficient for you to make a detention, to detain the individual or to arrest them. It's an important case. It is an important case, and realize that normally anonymous informants, by anonymous informant, we're talking about someone who not only do they not identify themselves, they don't give you even enough information to realize that they might even have credibility. In some cases, an anonymous informant may give you so much information that the individual might be able to use that, but generally they do not. Traffic stop cases, the Arizona versus Johnson case, the basic rule, vehicle seized, once the vehicle is detained for traffic violation, once the vehicle has been detained, everyone in the vehicle is considered to be detained. If you're going to search anybody, though, you need they're particularized. You have to have an actual reasonable suspicion about each or any person in there before they can be searched. And the arrest situation, generally the arrest situation gives you the right to search the individual and everything within their wingspan. You need probable cause, and this is a situation where in some cases you need a warrant. If someone is in their home where they reside, you need an arrest warrant to arrest that individual, to enter that home. If they're at someone else's house, you need a search warrant for that residence and the arrest warrant for the individual. That's a constitutional requirement, or that arrest will be unconstitutional. Lastly, the deadly force issue. Seizure is unreasonable when it's excessive, and the major case in that area is also in your text, Tennessee versus Garner. And basically in Garner, the individual it was a statute, the fleeing fugitive statute. They used deadly force. The Supreme Court ruled that just the fact that someone is fleeing and they've committed any crime is not sufficient to allow the use of the ultimate seizure, which is deadly force. That individual actually had to be presenting a threat to you or to someone else, or had committed a violent crime, or had tried to commit a violent crime, was a threat to the public. When escaping from you, at that point, the Supreme Court basically said that's the only time that deadly force would be constitutional in its use. Just the fact that someone was running from the police is not sufficient, even if it's a felony crime, to utilize deadly force on that basis alone, which is what the statute had allowed. And lastly, if you look at the U.S. versus King case, it's a good case to look at for a lot of the requirements for the affidavits that are used in search and arrest warrants. It's especially good if you're planning to go in law enforcement. It's kind of a good training case. And I think that wraps it up. It's a brief session, quick overview. I realize we'll be hitting this again on the next video, where we'll be going back into the Fourth Amendment again, and also looking at Chapter 5, where we look at some of the more unique areas of surveillance, which also involves the Fourth Amendment. Thank you.